Okay, as people are taking their seats, we do have a new CLE Session Code for this panel. The session code is B0201. B0201. And we will flash this again at the end of my brief talk about the Supreme Court analytics, and it'll remain up for you to copy down. But there is a new code to write down in your blue sheet. Okay, with that, I will start our next panel. I will be presenting just for a few minutes some data analysis of the last term and put it in relationship to the Supreme Court's docket historically for IP cases. And then my colleague, Professor Carolyn Shapiro, will be moderating the panel that's previewing the upcoming 2 IP cases before the court and also looking at cert petitions that are pending before the court. Okay, so without further ado, bottom line is, in terms of the last term, it can be summarized as same old, same old. It also could be summarized as times are a-changing. This is sort of a classic Gregory move to contradict yourself, but come up with a good explanation for why that contradiction makes sense. We will be looking at 4 factors that are shown on the screen. And these slides, by the way, are available in your program materials as well. These 4 factors we've looked at for the past few years, from year to year, so we'll give you kind of the historical trend, if there is one, in terms of how these factors have cashed out in the cases. Now, in terms of a reversal rate, here's where it's sort of same old, same old. Court steps in, Supreme Court steps in to reverse primarily Federal Circuit cases involving patent, and that's not surprising because the Federal Circuit's the only appellate court reviewing patent cases, so you need some other court, a higher court here to step in, and it was 2/3 of the cases. That's pretty similar to past years. Unanimity has changed, and this is where times are changing. None of the decisions were unanimous, primarily because Justice Gorsuch, whose name we've heard repeatedly in the past 3 panels, dissented in 2 IP cases. He wrote the majority in the 3rd case. Okay, so that's a major difference. In terms of voting alignments, we do have these interesting voting alignments with 2 dissents by Gorsuch, one joined by Breyer, the other joined by Roberts, but then we had the ideological breakdown that was just discussed in the SAS Institute panel just a few minutes ago, which is, as Greg Castanias characterized it, not an IP case, not framed as an IP case at least. Next factor is Solicitor General's participation. Typically, the United States values the position of the United States in these IP cases, and that remained pretty much true here over the majority of times, 2 out of 3 cases favoring the view of the Solicitor General of the United States. And this is pretty consistent with the past terms that we've looked at. Next factor is the questions and oral argument. There is a well-established literature establishing that justices tend to ask more questions of the side that they are going to vote against. And we've cited in our materials some of the literature. This term, at least in terms of the aggregate, it didn't play out that way, even though in past years it has. The reason why it didn't play out that way is that Justice Gorsuch dissented, and he asked the most questions of all the justices, so he skewed the result that we have normally found in the aggregate totals. But if you look at, and here are the, here are the total number of questions per justice. Obviously, Justice Gorsuch has a profound interest in IP cases, even if you characterize SAS Institute as sort of not a hardcore IP case, at least as how it's framed. The other 2 cases, certainly he asked a lot of questions as well. But if you analyze the questions by justice individually, that disagreement gap correlation played out almost 100%. So basically from this graphic, just look at the pictures that are in color. It represents the justices who asked more questions to the side they voted against ultimately, and it was nearly 100% of the times. There are only 2 exceptions noted down below, but we try to explain the reason why in the caption below. Professors Jacoby and Sag are doing this interesting analysis of question analysis, building on this literature. I don't have time to go through all of this, but basically they're measuring the strength of the correlation of asking more questions to the side you vote against, and the longer the graph bar is, the stronger the correlation is for the justice. So Gorsuch, for instance, is very strong, and Kennedy was there. Gorsuch very strong there, and Sotomayor was strong there, and Gorsuch strong there. And we provided their blog post in the materials for you to read. You can also check out their website at scotusoa.com for more of their continuing analysis. They're going beyond IP cases as well. So the bottom line is, in terms of this past term, it looks very similar to the terms that we've analyzed in previous years, except Justice Gorsuch, I believe it's quite clear, and Greg Castanias referred to this before, is a sort of a highly interested justice in IP cases. If sort of practical advice to the practitioners, you definitely want to think about how the case will play in Justice Gorsuch's view. He's not the only one, obviously, but I think it's quite clear he has an active interest in IP cases and will continue to be a force on the court in those cases. Just a couple of quick last slides. In terms of historical trends, this is pretty similar to what's happening this decade. It's the highest decade average of IP cases per term over 5 a year, and that's about more than double most of the previous decades going back to 1950. And as I alluded to already, it's mainly the patent cases that are being taken by the Supreme Court, often to reverse them. Okay, so with that, I will turn it over to the panel. Here again is the session code for those of you who came in late.
Thank you, Ed. I'm Carolyn Shapiro. As Ed said, I'm on the faculty here at Chicago-Kent. I co-direct our Institute on the Supreme Court of the United States, and I bring that expertise, but absolutely no expertise in IP to this panel. But I am happy to introduce our panelists who do bring lots of expertise on IP, some of whom you've already heard from today, sitting next to me. And I'm not going to read bios. I'm just going to remind you who we have up here. Greg Castanias, partner at Jones Day. Ruthanne Deutsch, partner at Deutsch Hunt. Kathryn Kayali from Williams and Connolly. John O'Quinn from Kirkland and Ellis, and Aaron Panner from Kellogg Hansen in DC. And what we're going to start by doing is talk about the 2 cases that have already been accepted for this coming term. In both cases, the petitioner has filed their brief, and we're waiting to hear from the respondent, and we're fortunate to have a lawyer for a party in each of these cases here. And we're going to start with you, Aaron. Aaron represents the petitioner in Fourth Estate Public Benefit Corporation versus WallStreet.com. And I've asked Aaron to start by just explaining what the case is about.
Sure. So this presents a statutory construction question that split the circuits. It's sort of what the Supreme Court does for a living. There's 2 circuits that had been on one side, 2 circuits on the other, and now and the government had even supported cert, although they oppose our position. And the question that's presented involves the Copyright Act. Under the Copyright Act, registration is not required to get a copyright. It's not a condition of copyright. However, before bringing an infringement suit, the statute says, the statute actually is written in the negative. It says no infringement suit can be started until registration has been made. I'm cutting out some words. And so that phrase, registration has been made, the question arises, well, what does that mean? What does it mean? What does registration mean there? Does it mean that the copyright owner has filed the application and submitted the required deposit of copies and paid the fee? Is that making registration? Or does it mean that there's actually been a certificate of registration granted by the Copyright Office such that a decision has been reached? As I say, commentators were split on this, and the circuits were split on this, and now it will get resolved.
So there's sort of it's a nice, juicy statutory interpretation question, which is nice for people like me who teach legislation and statutory interpretation. Maybe you could say a little bit about the policy issues. Like what are the arguments in favor? I'll ask you to argue in favor of your own client, but if you can nod to the arguments on the other side, that would be great.
Sure. So I'll actually start with what I think are the primary argument on the other side that's been pressed by the government in defending the position that the Copyright Office ought to act before a suit is allowed to go forward. And that is essentially that there was a benefit to the courts from having the copyright having the expertise of the Copyright Office brought to bear on applications. If copyrights, of course, are quite different from patents in that the copyright is granted by virtue of the fixation of the work in a tangible medium. That's what the statute says, and its registration is not required, and the Copyright Office doesn't get to grant a copyright, but nevertheless, the Copyright Office does examine applications for registration and make a decision, and the argument by the government is that, and I should say that if the Copyright Office denies registration, the government is permitted to intervene in the suit to essentially speak to the question of registrability in that infringement suit. And so the government's view is that there's a benefit to having the Copyright Office act first to ensure that the Copyright Office's right of participation is protected and potentially that the expertise of the office is brought to bear in that infringement suit. Now, we obviously have answers to why those concerns are not should not weigh very heavily in the calculus, including the fact that the Copyright Office can participate in infringement suits. It gets notice of all infringement suits that are filed anyway, and it can participate in any one it wants. And in the rare case where copyrightability is really at issue and the views of the office would be valuable, the court can use ordinary litigation management and primary jurisdiction, for example, to get the views of the office. On the other side, now the side wearing the white hat in this dispute.
The right side.
The problem that has arisen is that copyright registration and I think that there's copyright owners like the Copyright Office as a general matter. The Copyright Office is generally seen as being being appropriately protective of copyright owners' rights, but there are administrative difficulties with the Copyright Office that make registration process difficult. And as the Copyright Office has itself acknowledged, there are often significant delays with registration. As a result, in a circumstance where there is, for example, something that's published digitally, and there's an infringement that begins right away, the copyright owner cannot obtain injunctive relief or any relief until registration has been made. If that means filing with the Copyright Office, then the copyright owner has the ability promptly to make registration and bring an infringement action and protect the copyright owner's rights. But if they have to wait for the Copyright Office to act, often infringement can be going on for quite some time because copyright registration can take a long time. And there is a procedure in the Copyright Office for expedition, but it's expensive. It's $800 per work. And for a lot of copyright owners, that can be a significant burden, particularly if they're in a situation where there's a number of different works that they need to get registered. So essentially, the policy argument on the side of the copyright owner, to summarize, is that the requirement that the Copyright Office act before a suit be brought can often delay a suit in a way that is significantly undercuts the value of the intellectual property right.
Thank you. And Kathryn, I'm going to ask you now to talk a little bit about the case you're working on, Helsinn Healthcare versus Teva Pharmaceuticals USA, which also is a nice, juicy statutory interpretation question. But if you could describe what the case is about, that would be great.
Absolutely. So I'm going to give you the question presented, and then I want to unpack it to discuss what we think that means from a statutory interpretations perspective. So the QP in Helsinn is whether, under the AIA, an inventor's sale of an invention to a third party that is obligated to keep the invention confidential qualifies as prior art. And now it's the obligated to keep the invention confidential part that's pretty much the focus of the entire case. As I'm sure you're aware, the AIA changed Section 102, and in so doing, it changed the way we codified the on-sale bar. The old on-sale bar asked whether an invention was patented, described in a printed publication in this or foreign country, or in public use or on sale in this country. The new on-sale bar asks whether the claimed invention was patented, described in a printed publication, or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention. So there's a change in the law. The new AIA provision, the AIA version of the on-sale bar does two things. First, it adds this or otherwise available to the public language, and second, it removes the territoriality restriction about where invalidating sales can occur. So it used to be that a sale abroad didn't matter for purposes of the on-sale bar, and now a sale abroad can matter very much. So Helsinn has been dubbed the secret sale case, which I think is a really useful moniker, but important to unpack what that means in this case. Helsinn is a small pharmaceutical company, and in the process of developing a drug called Aloxi, it entered into a licensing agreement and a purchase agreement with a co-development partner called MGI. And it entered into that purchase agreement more than a year before it filed its provisional patent application. But that purchase agreement did two very important things. One, it helped Helsinn get the upfront money it needed to continue developing. But two, it required MGI to keep the details, not just the details, but the fact of the claimed invention secret from the public. MGI was not permitted to disclose the inventive aspects of the drug that Helsinn was developing. So fast forward several years, and Helsinn eventually gets an approved drug product called Aloxi, and we get ANDA litigation, and Teva argues that that this purchase agreement entered into a year before the critical date is invalidating under the on-sale bar. And the district court said, no, the new on-sale bar requires that an invention be made available to the public, and this purchase agreement disclosed the invention to MGI, but no one else knew about the invention. Well, the Federal Circuit then reversed and said, no, new 102, the AIA did not change the meaning of the on-sale bar. This otherwise available to the public doesn't mean that that the invention has to be made available to the public in the sense that the public has access to the information. What the Federal Circuit focused on is the fact that MGI and Helsinn announced the fact of their sale to the public. So they didn't say what they had sold, but they publicized the fact that they had entered into the agreement, and the Federal Circuit said, I'm not sure what wouldn't be enough, but that's enough to make something available to the public. So the juicy statutory interpretation question here is, what does available to the public mean in this context? If you provide a co-development partner with your invention under an obligation of confidentiality and no one else finds out about that invention, they honor that obligation. Have you made your invention available to the public? And thus have you completed an invalidating sale under 102B, under AIA 102B?
So one question I have is is there evidence that this was a question in the legislative history that Congress was thinking about when it enacted the AIA?
Yes, so, and speaking as Helsin's counsel, I'll tell you that I think there's remarkably clear legislative history. But that's, that's, the other side might speak differently, but.
We've got you here, so.
But, yeah, that's right. The Federal Circuit had interpreted 102B previously to require, to say that even if a sale isn't available, even if a sale is secret, even if the sale is completely confidential, and an inventor sells their invention before the critical date, that's an invalidating sale. There's evidence in the legislative history that Congress recognized that's what the Federal Circuit had done and set out to overrule that precedent. For instance, it said, we view secret sale cases as a trap for the unwary inventor, for people who don't understand that these co-development agreements might later turn out to be invalidating. And so there's a lot of clear statements, for instance, in the committee report, that this was something very much on Congress's mind. And that's particularly true because one thing the AIA did, as everyone knows, is convert us to a first-to-file system. One of the old justifications for the on-sale bar was that it would encourage prompt entry into the patent system. And now we have a first-to-file system that kind of does that on its own. You can't sit on your rights because someone might beat you to the patent office, whereas before you might be able to swear behind and prove that in fact you were the first inventor. So Congress recognized that change. It also recognized the fact that it expanded the territorial reach of the on-sale bar and linked all of those provisions together and suggested that its intention was to prohibit secret sales from being invalidating.
Thank you. Before we move on to talk about other things that we might get to look forward to in the coming term, I just want to invite the panelists to weigh in on either Fourth Estate or Helsinn Healthcare, if any of you have comments or thoughts. Ruthanne.
A few things. I think in both cases, the kind of elephant in the room, as Professor Lee's presentation highlighted, is going to be what the SG does or says. And in the Fourth Estate case, they're on record in the cert papers on the other side, and that typically is pretty convincing for the court. In these kinds of what Justice Ginsburg used to call them, the coin toss statutory interpretation cases, where you can make textual arguments on both sides and there's policy arguments on both sides, and at the end of the day, what the parties that are affected really want is a clear, bright line, nationally uniform rule that they can contract around in these situations. So, and then in the Helsinn case, the Federal Circuit, the earlier decision, the secret sale decision, rejected the government's position in that case, right? So
That's right.
And has the SG weighed in on your case yet?
The SG has weighed in. They filed a brief in support of our position, which we're very happy to see, and basically suggesting that unless a sale makes the invention available to the consuming public, then you've not had an invalidating sale under the AIA's version of the on-sale bar.
So I think in both those cases, that's going to carry a lot of weight with the court, would be my guess.
The only observation I would add is it's striking to me that both of these cases are really not, quintessentially IP cases. I mean, they happen to involve different forms of intellectual property, but they're just cases about statutory interpretation. And if you look back to the three big cases from last term, Greg made the point, rightly so, that SAS wasn't pitched as and really isn't thought of as an IP case. And I'd say the same was true for the other two cases as well. Certainly, oil states, not an IP case. It was really about foundational issues in terms of the administrative state. It was very similar to some issues that have come up from bankruptcy courts. And even Western GECO, which probably was the most sort of IP focused, it was itself, questions about extraterritoriality and questions of statute interpretation and how you put some of these things together. And so, to me, an interesting trend here is that yes, the court is taking more IP cases, probably because there are more IP cases out there and they're important to the economy and they're important to litigants. But the court's not taking them because they're IP cases. They're taking them because they present interesting legal issues that happen to involve IP.
Yeah, I would second that, and I'd just say, Aaron, don't fret. The SG can be beaten. And in particular, if you jump off of Ruthanne's comment about Justice Ginsburg's view, your position is not one that can be contracted around, because your position is that the copyright holder has done everything they can possibly do when they send the registration in, and then it's completely out of their hands, it's out of their control. And once again, you have the biggest problem you have in your case is that the administrative state, as it were, isn't doing the work in a timely fashion. If they were registering upon receipt, your case probably would never come up. But that's not happening. And so I think you have as good a chance as any. You've got 4 votes to grant. So I'd like to think that you have a chance to find a 5th out there somewhere on a statutory interpretation basis.
Well, thank you. I'm wondering if I could ask you to weigh in on some of the pending cert petitions. Some of the folks at the table are on one side or the other of some of these petitions. John, you had indicated that you have filed op-cert briefs in a couple of the cases that the court is considering. We'll be deciding actually next week whether to take up. If you could talk a little bit about those.
Yeah, sure. I find myself in the somewhat awkward position of opposing cert in a couple of cases that have been identified by various outlets as cases to watch. And of course, my strong preference would be that there's nothing to see here. It's not interesting. And while that's certainly how my clients in those cases hope the court looks at it, I actually think in both of these cases it also happens to be true, and that is with respect to one case, a case called Regeneron Pharmaceuticals versus Maris. Regeneron, the petitioner, tees it up, and the question that they present, when you hear it, you'll think, wow, boy, there's really something interesting going on here. Whether a patent right can be fully extinguished based on misconduct committed by the patentee's counsel during federal district court litigation to enforce the patent right, which sounds very ominous and scary when you cast it that way.
And it echoes oil states QP.
What's that?
It echoes oil states QP.
Yeah, there's some of that to it too. But when you understand what's actually going on in that case, that's not what was happening. This was routine application of Rule 37. Rule 37 of the Federal Rules of Civil Procedure governs sanctions that arise from discovery misconduct in litigation. And guess what? Under Rule 37, as all litigators know, if you don't produce things that you're supposed to produce and you engage in misconduct in litigation, court's entitled to draw an adverse inference with respect to one of the elements of the case, and that's what ultimately happened. Is the court drew an adverse inference, actually to one of the sub-elements on an issue that on an issue that ultimately then fed into the ultimate determination of inequitable conduct. And so for us, I think it's actually it's very straightforward. Like it's not unique, it's not patent unique, and what the district court did and what the Federal Circuit affirmed is routine application of Rule 37. And the only thing that would have been remarkable would have been if the Federal Circuit had gone the other way and said, well, there's something special about patents that means that you can't apply Rule 37 to operate the way it otherwise normally would. So while they have a fair bit of amicus support on their side, I'm optimistic that the court will see it our way and that this will not be a case that you will be interested in next term.
So we may never know, because we probably, at least you and I, may not be around when the cert pool memos become public, but the one you're hoping for is the one that says fact-bound deny, right?
That's the one.
And could you say something about the Bombardier case?
Yeah, so the other one that I have is this case, Bombardier Recreational Vehicles versus Arctic Cat. We represent Arctic Cat, and that's a case kind of a follow-on to HALO. And the argument that's being made by the petitioners there is that at the same time that the Supreme Court was rejecting the Federal Circuit's rigid standard for willful infringement, that it actually also, amped up the requirement for proving willfulness to require knowing or intentional infringement as opposed to just reckless infringement. Reckless, of course, at common law is usually enough to satisfy a willfulness standard, not just in patent law, but in many other ways. So our view on that one is that the whole premise of the question presented on whether or not the Federal Circuit erred by not requiring knowing or intentional conduct is premised on a fundamental misreading of HALO and thinking that HALO did kind of the opposite of what HALO was purporting to do at the same time, that it was striking down the Federal Circuit's, quote-unquote, unduly rigid standard.
Aaron, you've got a cert petition pending in the Smart Flash versus Samsung Electronics case. Could you talk a little bit about that case?
Sure. So the principal question that's presented in that one is one of the issues that's been kind of floating around in the earlier panels regarding the AIA and the scheme for the various kinds of review, IPR, post-grant review, CBM, that were established by the AIA. And so the principal question in that case involves whether, given the authority that administrative patent judges exercise, they are principal officers of the United States within the meaning of the Constitution. And the reason that matters is that administrative patent judges are not appointed by the President and confirmed by the Senate. And therefore, if they are principal officers, their adjudications are essentially null, or, I guess, at least voidable if challenged on review. And the issue with respect to the Appointments Clause, I should say there's also a Fifth Amendment due process retroactivity challenge that's also raised in that case. But the Appointments Clause issue was not raised before the Federal Circuit, and so that's probably, that may well be a vehicle problem that causes the court to take a pass on the issue, at least in this case. And there's also, as I'm sure will come up in later panels today, there's also been some developments in terms of the way that the PTAB panels are going to be organized, and that could also affect the analysis of that issue. So, but in any event, I mean, this is an issue that is also pending in a Federal Circuit case where it's being fully fleshed out, and it's, I think it's an issue that, depending on what internal changes the PTO makes with regard to PTAB procedure, is one that eventually could either cause changes with regard to how the PTAB is organized, or may eventually get looked at.
So is the Appointments Clause issue one that is sort of opened by the Lucia versus SEC case?
I wouldn't say it was opened by it. Certainly Lucia brings additional focus to the question. These things have come up before, and sometimes the challenges have had success. In my old age, my memory for case names has gotten really, really bad. But there was a challenge to the special tax judges that was successful. So this is an issue that has cropped up in various ways. And interestingly, John Duffy had written an article about an issue that actually caused a change in the way that the administrative patent judges were appointed, because they were not appointed in a way that was consistent with them even being officers, because they were being appointed by the director and not by the secretary. And as a result of that article, that was changed before it was litigated.
So I'd like to invite everybody on the panel to jump in if there are particular cases, the ones we've already discussed, or others that you think bear watching.
Well, I think there's one that's in the materials that is worth watching that we haven't talked about yet, and that's this Amgen versus Sanofi case dealing with the written description requirement of the patent statute. As I suspect most of the audience knows, the Federal Circuit in Banks several years ago reaffirmed that there are separate written description and enablement requirements out of the same section of Section 112 of the patent statute. I'm beginning to sense, both at the district court level and at the Federal Circuit level, more challenges on grounds of enablement and grounds of written description coming through the system, and I think that it's going to be soon the case that the court has to decide both whether there are distinct requirements and whether or not there are distinct requirements, what requirements are most consistent with the statute. And again, here you have the lesson of, is this a patent case or is this a statutory construction case? Keep in mind that in most statutory construction cases, the Supreme Court can wait and let the issue percolate and get decided by a bunch of different circuits before it takes up an issue of statutory construction. When it's one, however, like the construction of Section 112 of the Patent Act, there's only one Federal Court of Appeals that will ever decide that issue with a hypothetical possibility of it coming up in a non-mandatory counterclaim in another circuit. But for the most part, you're not going to have to wait for a circuit split. And the Amgen petition is very good. It's very clear, and it squarely presents this issue of whether the had possession standard that the Federal Circuit and before the CCPA has been applying for purposes of the so-called written description requirement, whether that is consistent with the statute. And so I expect that to get some attention. It's been a little bit of a sleeper so far.
Ruthanne?
Yeah, I just wanted to mention the advanced auto case, which is the patent takings case, that advanced audio, devices, which presents the takings question that was left open in oil states. I think it's hard, but it's something that we talked about in the other panel, and it's sort of a pair with the smart flash in my mind of, two of probably many more to come, petitions that are going to be targeted at Justice Gorsuch and his willingness to use patent law to, go after the administrative state. I don't think he's really interested in IP law. I think he's interested in attacking the administrative state.
Which is running IP law.
Yeah, which is right now running IP law. And I think it's interesting if you contrast these cases with the Regeneron case. I think there are people on the court that are willing to say patents are special if it means getting at some of these admin law issues that are troubling them. But I don't think they're willing to say, and we know that they're not willing to say patents are special when it comes to protecting the authority of Article III judges. And so eBay and other cases like that, and, an opinion, Judge Dykes, I think it was a dissent where he said patent law shouldn't be an island. That holds for the court when protecting their own sphere. But I think they're willing to look at it a little differently if it's an angle into broader admin concerns that they see. How that's going to play out in these specific petitions, it's really hard to predict, especially because the September 24th conference, they're not going to have 9 justices, so they're going to be very cautious. I think you're going to have less grants than you would otherwise.
Although there may be some relists or...
Yeah, and there may be CVSGs also, which is a way of especially in cases involving federal statutes, they're likely to do.
So advanced audio is coming up to the court from a Rule 36 decision. And for those of you who don't know what Rule 36 is, that's where the day or the week after your argument, you get a letter. Well, it's not mailed to you anymore. It comes via email that says the judgment is affirmed. See Federal Circuit Rule 36. So there's no opinion that the court is being asked to review. Now, George can tell us that oil states was also a Rule 36, so that's not an impediment on the one hand. On the other hand, I think this issue is fundamentally different than the one in oil states because given that the Court in Oil States explicitly left this issue open, I can tell you that there are no fewer than 20 pending cases at the Federal Circuit that are raising this issue right now. The reason I can tell you that it's around 20 is that I've got at least 3 of them, and the United States government in response has filed a brief with a footnote showing all of the cases where this issue is being raised and saying that although this hadn't been raised before the board, this might be a good case to have it decided. So I agree with Ruthanne that this issue is important and it's one to keep an eye on. I don't know that advanced audio is going to be the vehicle by which it gets to the court.
Kathryn, did you want to weigh in on any of these or other cases that are pending?
No, I think the point that Ruthanne made is a very interesting one with respect, and it ties into the grants that we've seen this term, both my client and Aaron's. The court is interested in IP, but it's also interested in statutory interpretation and ensuring that patent law is not an island, in Judge Dyke's words. And I think we've seen a lot of opinions lately suggesting that trying to create an island will not be well received. And so query whether the interest will continue in a true IP sense or the interest will continue in an administrative sense with Judge Gorsuch, or just in a statutory interpretation sense, in the idea that the statutes mean what they mean, whether or not we're talking about patent law or something else.
Well, and on the theme of patent law not being an island, there's one case that I'm watching that I think will be of interest to the Supreme Court, or at least poses an issue that will be of interest to the Supreme Court, whether it takes it in that case or in some other, and that is the St. Regis Mohawk tribe case, which goes to the issue of sovereign immunity, and when a tribe asserts a sovereign immunity within an IPR, does that apply? Because is that more of an adjudicatory process, or is it a la oil states, more the government correcting its own work, and you can't a federally recognized Indian tribe cannot assert sovereign immunity against the United States itself. And so I think that issue is out there. It might be that the court will be, more interested in seeing, well, what happens when sovereign immunity issues involving states appear. So I don't know that St. Regis is necessarily destined for the Supreme Court, but I think it's one that the court's going to be interested in.
Well, any last words before we send everybody off to lunch? I'd like to thank the panel and the attentive audience, and I look forward to the rest of the afternoon.